Hi, I'm Sabine, the Purpose Lawyer. Thank you for listening. Please don't forget to like and subscribe to this podcast. It really goes a long way. It helps us spread the good word. And if you or anybody you know is in the market for legacy or estate planning or business or trademarks, please reach out to our firm. It's the Ambitious Legacy Firm. We are licensed in New York and New Jersey, but we have service partners in all states. So we'd love to work with you. Asset protection, legacy planning, trademarks, we got you. All right. So it's the ambitiouslegacyfirm.com. Now let's get into the episode. Welcome to another episode of the Ambitious Legacy Podcast. I'm your host, being the Purpose Lawyer. Thank you for listening, and thank you for helping me be on purpose as per usual. So today I wanted to talk about something that happened in the news recently, and it's a really sad story, but at least it does give us, not at least, but it gives us an opportunity to kind of go through some very random set of things, but a bunch of things that are really relevant. And it's interesting to see how all these things sort of play out in one story, all these issues, so that you guys know that I'm really not just trying to create fear in your hearts, but I'm trying to help educate on things that really do happen and simple things that we could do to put in place to just prevent a lot of these things happening. So I'm going to talk about, I think it's 4 things. So one, putting the right person in charge. So, we'll sort of get into who can be in charge of your estate and what that should look like, and all of the dynamics that kind of happen in this story. And then we'll talk about dealing with complex family dynamics. Kind of runs through this whole story, but putting the right person in place, dealing with complex family dynamics. Number 3 is, can you email your will? Is that a thing? Let's get into talking about that. And then 4, will they kill me for my body parts? Right? And that's one of the things that people that I talk to all the time, that's one of the questions that kind of come up. So we'll get into all of these things, a bunch of random things, but let's talk about it. So the story that I'm getting into is Heche. She is a very well-known actress. She used to be married to Ellen Degeneres or dated her or something like that, but whatever the case is, she's been in tons of movies, etc. So unfortunately, she passed away last month at the age of 53. Okay, so this does happen all the time. I'm telling you, at the age of 53, no will, unfortunately. Even as we've seen plenty of times in the past, the rich and famous who don't have a money issue still are not putting these things in place. So we want to really, guys, don't let this be part of your story. Obviously, we hope everyone dies of old age, but we never know. So anyway, she died at the age of 53, had a 20-year-old son and a 13-year-old son. And so her 20-year-old son really is kind of the only one who's of age who can kind of step in to try to manage her estate. And that's sad, right? Because she literally died a month ago, and now her son has to be in a panic to try to figure out what to do about her estate. Because what happens is, especially when people have assets or have money, the vultures come in. So if you don't move quickly, then you might be trying to clean up a bigger mess than has already been left, right? So long story short, her son filed for papers to be the administrator of her estate, stating that she died without a will and that he needed to be in charge, and that he also wanted someone to be in charge to take care of his younger brother's interests, right? So he's petitioning the court for this. And of course, there's going to be opposition now, right? So her ex-boyfriend, who is the father of her other child, the younger child who's 13, who's saying, well, I should be the one who should be executor because, her first son, Homer, he's too young and he's irresponsible, and they weren't even talking at the time. That's not even relevant, but he's over the age of 18. So, California states that if you're over the age of 18, that you can be someone who is appointed as an executor or in a will, or an administrator, which would be someone who's appointed by the court, right, to be in charge of the estate. So first issue that we're dealing with is putting the right person in place. So because she didn't have any sort of will or other document, we don't know who should be in place, right? But the only thing we could do is rely on what the law says. And the law basically says, well, if you didn't put anybody in place, then we're going to go by intestacy. And intestacy just means that, if you die without a plan, here's a plan that we have for you. And it's going to be the next of kin, the next person in line. So she was not married. And so because she was not married, that would be her son, the 20-year-old 8-year-old son. But of course, now we have somebody else challenging this position that really should be no question, right? And that's part of the problem when estates have to go through the court system, is that like everything is up for dispute, everything is up for negotiation, right? If she had a plan put together, we're just going to assume that her estate is multiples of millions of dollars because she's an actress or actor, I should say, and she had multiple multi-million-dollar properties, right? So we're just going to assume at the very least that's what her estate is, a large estate. And when it comes to that, I really lost my train of thought, y'all. So when it comes to putting somebody, okay, the state gives you a plan and they say it's going to be the next of kin, going to be her son. And so, yes, when you're in court, this starts to become a debate, and people come in and just delay the whole thing, right? So it shouldn't even be something that's delayed, but it is becoming delayed because her younger son is not of age. So the person who would act for him is his guardian, his parent. And so now that parent, who was her ex-boyfriend, is now challenging the older son's position. And the things that he is saying is that he's not responsible, et cetera, et cetera. Those type of things are not really relevant because the courts they kind of look at black and white, right? Does this person fit the description? Then yes, we're going to kind of go with this. Now, I can't say if they are, right? Because once there is a challenge, they start to look at other things. They start to listen to other factors that may be placed in. So at the very least, this is going to delay the settling of her estate, that the ex-boyfriend is now coming in to challenge the son's position. And the thing about becoming an administrator or an executor, it's not that it gives you any sort of superior power, right? It doesn't give you, if you were someone who was going to receive from the estate, it doesn't give you any sort of extra benefit, like, okay, you may get paid for that particular position, depending on the size of the estate, but beyond that, and sometimes that's not even the case if it's written in the will or the trust or whatever document that you don't get paid. But it may be like a paying position. But beyond that, you don't get any special power, special decision-making situation. It's not up to your discretion. It's you being in a position where you're held to a higher standard and that you have to basically follow the rules of whatever the document is. So say it's a will or trust, you need to follow whatever it says to distribute those assets, but you're being basically supervised or regulated by the court as to what you're doing. If there is no will or trust document, then the court has to basically decide that you basically decides and instructs you as to how you can and should distribute the assets. So it's not really a position to fight for. However, I do know why people challenge it, because when you are in that position, although there are rules and regulations and standards that if you violate, you could either, you could be, fined, like you'll be charged. Obviously, you'd have to return any assets that you sort of waste or misuse, or you can be charged like criminally if you really do something that's wrong. But people don't always follow the rules, and people find ways to do fraud and scam and work their way around, certain systems. So I do understand why people, challenge these positions, because there are things where people spend the money that they're not supposed to spend as the administrator or the executor, or they make decisions, or they withhold assets. All kinds of stuff happen. But these questions and these sort of concerns should be decided by the person whose estate it is, right? The person whose life was lost. So it's more important than beforehand to avoid all of this confusion to make those decisions. So there's allegations that she was estranged from the son who wants to be the executor. Now, if that is the case, it would have been great for her to make that decision and say, hey, love my son, want him to get XYZ, but don't want him to be the executor. Or I really do want my ex to be the executor because I think he'd be in the best position to take care of my kids and make sure all this stuff, happens. Great, but that decision wasn't made. So now I'm sure we'll be talking about this again. Now it's going to be, a period of time where we're just arguing about figuring out this one step. This is like the very first step in settling an estate, who's going to be the executor or the administrator, and can't even get that far, right? So it's going to be a long road for them as it relates to this. And so let me just give you this one point. So when the state is selecting someone to be over an estate where someone passed without a will, like I said, they're going to look to who's the next of kin. Her oldest, and they start with your spouse. She's not married, so then it's her child. Her oldest child is wanting to do this. He's willing and he's presumably capable of doing this. And so I'm going to say that the courts are going to lean towards giving him the authority to manage the estate. And obviously, he's not going to do it on his own. He'll have professionals. He has a lawyer, and they'll be, helping him through this process. Now, if it were me, if I were the judge making the decision, I think that a third party, somebody who's not involved and not invested within the estate, being that we don't know what the person wanted, I think that should be the person who's going to manage the estate. And although it's going to cost the estate money, and it's going to go, obviously to whomever the court thinks is suitable, which is not always great value-wise for the estate, but at least we won't have the families feuding, right? We have a young man who's 20 years old and his younger brother who's 13. And, the younger brother's father, all of them are in this, sort of situation where it's causing a lot of strife and a lot of stress within the family. So at least to preserve that relationship, which I always think is most important, especially now they don't have their mom, a third party should really be the one to make the decision. But that's just me. Who am I? I mean, seriously. So that was just point number one, putting the right person in charge. How important is it to put the right person in charge because of all these sort of things that can pop up? Then two, we have dealing with complex family dynamics, right? Especially when there are children from different fathers. So Anne Heche had two children, one from her first relationship, the other one from her second relationship. She wasn't married to either one of these men, and she has two kids. So now you have two separate families, essentially, that have an interest in this estate. So that's one. So when you have situations like that, you have first marriages, second marriages, you have maybe older children, and your second or your spouse that's not their parent, things of that nature, those are ripe for family strife. Those are ripe for estates to be sort of like delayed and drawn out. And so, those type of situations, you really want to make sure that you have something in place, that you have a written, well-documented plan, whether it be a will or a trust or what have you. You have it reviewed by a lawyer, created by a lawyer, to make sure how, that these things are going to play out in the way that you intend them to. And I would even say having separate trusts created where one child is the beneficiary of this trust, another child is the beneficiary of that trust, would even be a situation that would be even more ideal, because nobody would have any claim to anything outside of that. Now, of course, I'm oversimplifying this, but that's just one thing that I sort of thought about. And so that's another thing that could avoid these family dynamics being strained, because we already know, like, in all communities, right, that when you have, different children from, different parents, that can always already be a strained situation, a strained relationship. And you can't, people just don't imagine how bad things get when the person who was there kind of holding it all together is no longer around. I kind of feel like a broken record saying that, but things change. And especially when these people are now technically not really related, right? We're only related by this one person. Of course, it's going to get ugly and nasty when there's money, sort of at stake. And so that's the other thing. Dealing with complex family dynamics, you really, in order to avoid these type of situations, you want to have your plan put in place. That's all I'm gonna say about that. And then the other interesting thing about this story, I thought, was, can you email a will? So in this story, the ex-boyfriend is basically stating that, she didn't die without a will. Actually, she emailed me her will in 2011 stating that she wanted me to get all of her assets so that I can take care of the children or her child that they have together. And I'm like, okay. So now this has been introduced to the story and I'm interested to see how the courts are going to deal with this. A will being emailed to him and two other people, and I guess they're trying to say like those two other people are witnesses to this sort of online email will. This could kind of change everything in the way that we sort of do things if California was to, and I'm assuming this is California, that's where she lived and that's where she passed away, so that's what I'm going by. If California were to say, yeah, we're going to take this will as valid, being a valid will, and change the laws accordingly, or make a decision that leans to the laws being changed to allow for these online email wills. I don't know, right? But as for now, that is not a thing, right? So under California law, you cannot just send an email and say, hey, this is my will, this is what I was thinking, so yeah, let's do this. No. So in California, you have to be 18 years or older to draft a will, right? You have to be of sound mind and body, right? So we don't even know if she was of sound mind at that point. Sounds a little crazy to just send an email when you're perfectly well and able to say that this is how I want to leave my multi-million-dollar estate. Sounds a little crazy to me, but again, who am I? You have to also create the will, being freely and voluntarily creating that will. So nobody's forcing you, coercing you, or whatever. We don't know. Someone else could have got a hold of her phone, sent that email. Someone else, namely the person who's going to be benefiting from it. We have no idea, right? We have no idea what the circumstances are around that. So this is what I'm thinking the court is going to say. The other thing you need for a will in California is that it needs to be a physical document, right? So it could have been something you create on a computer, print it out, which is normally how we do it, have it signed and witnessed. It has to be witnessed by at least two individuals in order for it to be a valid will in California. Doesn't need to be notarized, but these are all the things that are required for this will to be valid. So he could say what he want to say about that email that he got, but that's probably not going to work. It's probably not going to stand up in court. I'm going to go ahead and say that right now, but it will be interesting to see how the courts deal with that, right? So again, can you email your will? No, not a thing as of now in any state that I'm aware of. So if you know something, you hear something, please let me know because I'm interested in knowing. And then finally, will they kill me for my body parts? You know how many times people say to me when we talk about how they want to sort of not leave. When I ask them, what do they want to do in terms of their organ donating decision, right? Do they want to be an organ donor or whatever? It's like sort of split. Some clients are like, yeah, just if it works, let them take it, and that's fine. But a lot of people do say, I'm not doing that. That they think that it's a thing where like hospitals won't really try to save your life or whatever the case is if you are an organ donor. Like if there's somebody else waiting for that organ, they're going to be like, okay, go ahead and pull that plug because we have someone else waiting for this. I honestly do not know. I mean, I've heard people in the medical field say things that, might lend to that, but I am not sure. It's really a decision that you should sort of make on your own, however you want to go. But in this particular case, it says that, so her accident happened on August 5th of this year, and they pulled the plug on August 14th, and to salvage her organs for organ donating. So it wasn't really like a short period of time, in my opinion. However, and if she didn't leave a plan, that means that she didn't necessarily say how she wanted her, if she wanted to be kept alive or if she didn't want to be kept alive. So I find that part interesting because then what are they going by? And I'm not 100% sure for California, how their healthcare proxy situation works. Maybe she had one on file with some hospital or something like that, and they went by that. Or maybe because she's a movie star, they had one, for that particular reason. But your healthcare proxy would be the document to basically allow someone to make decisions whether or not to pull the plug or not pull the plug, keep you alive or what have you. And sometimes clients would choose to have their agent decide if they want to be an organ donor or not. So totally up to you. But I thought this case was very interesting with all these different things that happened. So, Sabine's not making it up. She's really telling us the stuff that happens in these families. It's really like a lot. I could go on and on and on about this. all these different stories, all these different issues that kind of come up with in this one story. So we'll stay tuned, and we'll probably talk about it again when we find out more details about what's going on. I hope this was helpful for you. And if you are concerned about any of the things that I kind of talked about today, or you know someone who should be concerned about the stuff I talked about today, please feel free to reach out to my firm, the Ambitious Legacy Firm. We deal with these protecting people to prevent these type of issues. We do this stuff all the time. I talk about this stuff all the time. And so we'd be happy to consult with you, help you through your issues. And if we can't help you, we're happy to refer you to our network of amazing planning attorneys and professionals. So thank you for listening, and I will see you next time.